Well, good evening. My name is Leslie Bottomore,
And I'm Alexis Squire.
and we're both here to talk about collaborative law. And here's my website and Alexis Squire's website. If you are interested in contacting either one of us after this, we welcome that. This PowerPoint presentation came from the Collaborative Law Professionals of Pierce County, CLPPC. We offer a 2-day basic training in collaborative law. So this is really a short synopsis from that. There are different providers around the state who offer the same training. The International Academy of Collaborative Professionals has a set of professional standards for trainings, both basic training and more advanced collaborative law training. And this is just a small piece of what fits those standards. So an introduction, really, to collaborative law. So what's the difference between collaborative law and litigation? And this is a quote from Abraham Lincoln. Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has superior opportunity of being a good man or woman. There will still be business enough. And I think we find this, that it's a legitimate form of practice, collaborative law. It is a form of dispute resolution, and it is, in my mind, cost-effective, private, and avoids a waste of time because you're working toward resolution from the get-go. Oh, you guys skipped one.
So this is a flow chart that describes the difference, the different, on a continuum, the difference in how much control the parties have in the dispute. So it goes from high control when they're negotiating just over the kitchen table and don't have any lawyers or any third parties involved in the discussion, to the least amount of control, which is having a judge or a jury make the decision for the parties. A lot of this presentation is focused on family law disputes because that is the most active area of the law in which people are practicing collaborative law. But there is kind of a stirring of more emphasis on a collaborative approach in other kinds of disputes, and it certainly is suitable for areas such as land use, or it's particularly suitable in areas of the law where the parties have a vested interest in maintaining some sort of relationship after the dispute is over. So neighbors, family members. We do have a good active group of attorneys who practice collaborative law in the area of probate also. So as you can see then, this is actually something that I give all of my clients at my initial consultation with them when I'm describing their different opportunities for ways to resolve their dispute. And when I'm screening my client and screening their case to determine whether it's appropriate for a collaborative case. And I find that this is a really helpful way to help them get their brains around all the, the different mechanisms that they can work through to resolve their dispute. So it goes from kitchen table to mediation, where you can see that wall is where the attorneys and the specialists are kind of behind the scenes giving consultation, but the parties are together there with the mediator. What typically happens in family law cases and litigation is that mediation occurs in two separate rooms, and parties who were married for however many years end up resolving their dispute in 2 separate rooms and never even seeing each other. So that's what we call a settlement conference. Then collaborative practice is a different form of ADR, where the parties are always at the same table and the attorneys are there always with the parties, and any negotiations that happen are done around the same table together. The other important piece of it is that all the discussions about the law are together around the same table. So whereas where you get to the next slide in the attorney settlement, you have the attorneys in separate rooms with their separate clients. The attorneys communicate back and forth. You're jumping through several individuals with communication that may or may not be accurate by the time you get to the actual negotiation and back to the party. So collaborative practice, all of that communication is done around the same table, and we'll explain more about that.
Yeah.
And then you get to the settlement conference, which is what I described before, where mediation is occurring. It's much more directive, but the parties are really separated from each other and don't really have to face each other and talk about the issues that they're in dispute about. They don't have to face each other, and the mediator jumps back and forth between the rooms. And then, of course, there's the court. So anyway, this is an effective tool to explain to your client the different forms of dispute resolution.
And I could say several things just on this one slide. I like to characterize collaborative practice as being about self-determination, because it's really client-centered. It's about the client's interests underlying their positions. And they have a team of professionals working together to support them toward that resolution. Also, if you think of mediation with attorneys involved, often you've got the clients, they've got their independent legal counsel, and then you've got the private mediator. So they're really paying 3 highly paid professionals rather than 2 independent lawyers who are really working using interest-based negotiation skills and conflict resolution skills to work toward a resolution as a mediator would, but you're working as a team. And the other thing to point out is that collaborative law is now codified. It'll be 3 years in July in the state of Washington under RCW 7.77. And we were the 7th state, I believe, in the nation. And last I checked, there were some 13, 14 states who've now adopted the Uniform Collaborative Law Act. So it does require independent legal counsel for both parties. And there's this concept of informed consent also with this chart and the way Alexis described her first meeting with her client, that as a collaborative law lawyer, we really honor our duty of explaining the different process options that people have to resolve their disputes, and that's our duty. It's kind of like you go to a surgeon, you're going to get surgery. Well, you go to a litigator, you're probably going to get litigation. And we both litigate also. So it's not about demonizing the court. The court has a place. There are disputes that aren't conducive for collaborative law, but really explaining to clients or potential clients the options that they have so they can make an informed decision about how they resolve their dispute. And here's another similar chart. I think we can highlight creativity, parties maintaining control, building relationships or rebuilding relationships, reconfiguring relationships. And it might be 2 brothers who own a business together who are now dissolving their business, and or it might be employer-employee, but I think more typically we see husband and wife. It's informal, it's flexible. Typically we're having 2-hour meetings, there's food on the table, and it's at a conference table in a private conference room. And we're addressing one issue at a time or a couple of issues at a time. So if people need breaks, they get breaks. If people want to reconvene at a later date, and they get homework. So there's work being done between meetings to keep the process moving along. So even the timeline, I think, when you're in court, I know in King County you're issued a case schedule, in Pierce County you're issued a case schedule, and you're mandated by those deadlines. In collaborative law, the clients really govern the timeline. So if they want to move more quickly, they can. If they want to move more slowly, they can. If their timelines aren't synchronized, they can work with a professional like a coach to synchronize their timeline. We talk about us being in a boat together, and we create a safe container for participants to resolve their disputes. So you don't want the boat to capsize by someone moving too quickly or someone moving too slowly. I don't know. Anything else?
No, I think it would be helpful to kind of walk through what it looks like a bit. And I think
Okay, let me see.
after the next slide. This is just.
Okay, just a little demo.
And I think one of the, and we'll try to help you see what the whole, what a case kind of looks like and what the key steps are in the process. But I think one of the misconceptions is that collaborative law requires a lot of process, and it's more expensive, therefore, than going through a more traditional litigated case or going through a mediation. And it's not, just like you can't say, when a client comes into your office saying, how much is this case going to cost me? You can't give an answer. And for the same, you can't really say whether a collaborative approach in one particular case is going to be more or less expensive than if that case went a different route. So I think that is a big misconception. So maybe can we go to the next slide?
Yeah, I like to say that collaborative law is not necessarily cheap. It's not kitchen table where there are no professionals involved. However, I think it's the best use of people's money. It's cost effective. I also think that lawyers in a collaborative law case can delegate a lot of what they might ordinarily do, like handling the emotions of the case, handling the finances of the case. Those things can be delegated to a more appropriate professional, like a financial specialist or a divorce coach or a child specialist. And traditionally, I think lawyers don't want to give up control. They don't want to give up certain items that they might have handled previously. And so it involves a lot of letting go, I think, more for the lawyers. We call it the paradigm shift from traditional practice.
And I think the other piece of it, too, is that a key component of the collaborative process is the team model. So the attorneys who each represent the parties are not considered opposing counsel. We don't call each other opposing counsel. We call each other Joe's attorney,
Right.
Joe's attorney or Mary Jane's attorney. So there isn't, the parties aren't adversaries. We rarely call them, I call them clients, not parties. We're still advocates. Attorneys are still advocates. But as team members for our clients and for the process that we're trying to facilitate, to help our parties reach a sustainable resolution and a gratifying resolution, part of our job is to pay attention to that process and make sure that we as team members are paying attention to how much money the parties have and whether they have the resources to take on a full collaborative team. So we have much more of an opportunity in a collaborative case, I believe, to consciously set up a procedure that recognizes the parties' economic circumstances and to be very intentional about how we use professionals and the professionals are jointly retained. So you have one financial specialist. You don't both have separate experts. You have one child specialist. You don't have competing parenting experts. And you can choose conscientiously how you engage those people and what issues they may or may not address. So you really have a pretty wide range of how much you engage the full collaborative process.
I just wanted to interject that for those of you who are here, we do have handouts. I see one of you has them. Feel free to grab those as we go along.
They're just the same, the PowerPoint, and there are a couple of flyers about collaborative law.
The other thing is when you have a full team where you have a financial specialist or a coach, that professional is a neutral, so more like a mediator really, while you have the independent counsel for both participants acting as advocates and looking out for the interests of not only your own client but the other client and the children. You've got that neutrality when you have a full professional team. So I think it can, people think that it may cost more, but it can tend to save in the end. So this outlines the traditional legal system being adversarial, not addressing the complexities related to families in transition, polarizing the parties. I think of it often as escalating the conflict instead of resolving the conflict, and being destructive to children. And again, there are those cases where I was in court today on a child abuse case, and clearly there are two parties who are not ready or able to engage in collaborative law. Collaborative law requires good faith, full and complete disclosure, and a willingness to work together. And it's not easy. A lot of people might think, well, it's easy. You have to have something to collaborate about. So you've got to have a dispute. If you don't have a dispute, then it's just an uncontested divorce, if it's a divorce case, or an uncontested probate or what have you. So you've got to have a dispute. And there has to be that willingness to work with the other participant face to face. So I've heard collaborative attorneys say it's not for sissies. I mean, you've got to be comfortable with conflict. Conflict is right there at the table. And that's why I think the International Academy of Collaborative Professionals requires these standards be met for training of professionals. So I would encourage any of you who are interested to go out and get the full-blown training, because it really teaches us how to resolve conflicts with folks right there at the table and be comfortable with that.
So like we said, this is kind of focused on divorce cases or family law disputes. Collaborative law kind of was generated from from the idea that a legal dispute, when people have legal disputes, in order to come to an agreement that is sustainable, that makes people feel like they fully vetted their dispute and they have that full closure, we need to address the psychological and emotional issues at play, as well as the financial and legal issues. So in collaborative law, typically we have a coach who is a mental health professional who assists the parties in dealing with the emotional and psychological piece of the dispute that can sometimes create barriers in barriers to communication and barriers to conflict resolution. And by having a coach there, the coach is typically at all of the 4 or 5-way meetings that the parties have together. Sometimes they're not. The parties individually usually see the coach outside of these four-way meetings to help move through some of those emotional and psychological pieces to, again, help them communicate. They're communication coaches of sorts. But the role of the coach is really about having somebody with a mental health background. So, we have, as Leslie was saying before, we kind of outsource. We as attorneys are able to outsource to people who are trained in those particular areas to help the parties with those particular issues. So the coach and a financial specialist is somebody who has is a trained financial person who can run future income analysis, cash flow analyses, things like that. So those are all team members that are engaged in the process. And then the interesting thing I find in collaborative law for divorces is that when that psychological piece is addressed, there's kind of a settling of the parties. They feel like they have an avenue. They don't have to use the litigation process, as often happens in divorce cases or in other litigation cases. They end up using the process to resolve unresolved psychological and emotional issues. And when we give the parties an outlet for that, a place to express themselves from their deepest core, with somebody there with a mental health background who can support them in that and be there to support the recipient of that information, they come to the table more ready to deal with the business and the financial aspects, the business part of the divorce. So that, I think, is a really important component to pull that psychological and emotional piece away and give that to somebody who has the professional background.
Then they're better able to problem solve. I just want to clarify too, the coach or child specialist, while they have training in either psychology, or it might be a master's in social work or marriage and family therapist, they're not acting as a therapist. In the case, they're acting as a coach, and there is a real distinction. Some folks might be in therapy, but the coach is involved really for the transitional piece, to get these folks to communicate better, to help problem solve, to synchronize their timelines, to not engage in personal attacks or disparaging remarks, that good faith piece. So they can, like Alexis said, be ready to problem solve. So it is voluntary. So, just like I said earlier, there's that array of options that people have, and you might have a client who is totally on board and wants to choose collaborative law, but they're worried about the other participant, the other party. So it's tricky, but it can be done to engage that other person. I tend to send out a packet, and I tend to have my client hand deliver it to the other participant. And it's a letter from me to my client, a packet from my client about collaborative law, and a packet for the other participant, usually the spouse. And it helps guide my client's conversation with his or her spouse so they get to the right place, rather than ending up in an attorney's office who does nothing but litigation. If I give a set of profiles, say 8 profiles of attorneys who I know to be collaboratively trained, it's just a starting point. And just like these brochures I've handed out today have websites for King County Collaborative Law and Collaborative Law Professionals of Pierce County and International Academy of Collaborative Professionals. Those are resources for people too, to find a professional who's truly walking the talk. And that'll kind of guide the other participant to collaborative law. It doesn't always work, but it often works. And so it's results oriented. It's looking toward resolution rather than conflict. Forward thinking. I think we talk about not looking in the rear view mirror, but looking in the, forward windshield. And we do cooperate, but there is a real distinction between collaborative law and what I think people term cooperative practice. Collaborative law, if we can back up a little bit, the International Academy of Collaborative Professionals just celebrated last October 25 years of collaborative law in Washington, D.C. And it started in Minnesota by an attorney by the name of Stu Webb, and he has a book out. There's so many books out. Just go to Amazon and look for collaborative law. There are all kinds of books about collaborative law. But he was engaged in high conflict divorce, family law work as an advocate, and he was in his 50s, and he told his wife, "I'm ready to retire. I'm tired of damaging families by dragging people to court." And he wrote a letter to the presiding judge, and his colleagues said, Stu, we need you. We need you on this case. Don't retire, please, stay on. And he said he would continue to work as a lawyer if they would all agree not to go to court. And there was born what we now call the participation agreement, which is a contract that's binding. It's voluntary, but it's binding, that 2 lawyers would sign, my collaborative colleague and I would sign, and our clients would sign. And it says you're not going to threaten court, you're not going to engage in discourse and interest-based negotiations, and when you reach an impasse, say, I'm just going to go to court. You can't do that. You're going to engage in good faith, full disclosure, work toward a resolution. And so there is a disqualification provision, and Stu Webb calls that the touchstone of the participation agreement. It's what a lot of, I think, traditional adversarial litigation attorneys think of as negative. You hear folks talk about, well, my client doesn't want to lose his lawyer. And I think of it more as a positive commitment toward resolution as a collaborative professional. That I'm not going to be afraid of losing my client because I'm working toward a resolution for my client. And it helps people to become more creative too, to think out of the box, to think in the box, to roll up their sleeves, work a little harder, have another meeting, brainstorm, work with the coach, whatever it takes to reach resolution rather than taking the easy way out and saying, well, I'll just go to court. So that's what really defines collaborative law. And Stu Webb continued to practice into his late 70s. He just retired last year. So he's been around at every conference that IACP has. And he's very, have you met him? Very soft-spoken and Buddhist approach to life. So very peace-oriented.
And I think the thing that I would add too is that that participation agreement is really what makes a collaborative law case a collaborative law case. And often we in family law will hear, this was a collaborative law case and it failed, and there was never a participation agreement signed. That is not a collaborative law case. If you don't sign a participation agreement, it may be a cooperative case where parties were really endeavoring to work cooperatively to resolve their dispute, but it's not a collaborative law case. So we often talk about it as collaborative with a capital C and collaborative with a small c. The capital C is collaborative practice sanctioned by the IACP.
Yeah.
And you'll see in the materials, collaborative should be capitalized. That's the collaborative practice that we're talking about today. We can all collaborate, little c, and it can be successful or not. But
Right.
that's not signing a participation agreement. And the other thing is that not only do the attorneys and the parties sign a participation agreement and have that disqualifier, and that disqualifier says if we fail in this process, essentially, we don't like to call it fail, but if the process terminates for whatever reason, and there are a number of reasons it could terminate, and any party can terminate it just because they don't want to participate anymore. If it does terminate, then the lawyers do have to withdraw, and these parties need to find new counsel. The the neutrals, who are most often a coach, a financial specialist, and possibly a child specialist, also typically sign that participation agreement. Now, sometimes people will have them not sign the participation agreement. I'm glad to talk about that further, but typically all of the neutrals sign that participation agreement as well. And that means that if that process does terminate, those neutrals can't be called as witnesses, just like the attorneys couldn't be called as witnesses anyway. But there's basically a lockdown on that collaborative process, similar to what there is in terms of confidentiality in a mediation process. But in this case, you've got what might otherwise be termed as experts that are also not available for the litigation process.
It really just protects the process, the integrity of the process. Let's see.
This is just what we were just
So,
talking
yeah, I mean, I would just say that it's not to be feared. I don't fear that I'm going to lose my client, and I don't think my client is fearful that he or she's going to lose me, because you're working toward a result. You're working in a positive direction, and so is the rest of your team. And also, I trust my collaborative colleague. So if, for example, my client doesn't want to disclose something, I'm going to have a conversation with my client about that could result potentially in the termination of the process, and we don't want that. So we need to disclose it because it's relevant to the matter. And so you have trained professionals who are working with the clients to encourage them, even when they haven't done the paradigm shift, to engage in full disclosure. And keep working in that direction of resolution. And I think a lot of litigation attorneys talk about failed collaborative law cases. And my point about that is that that's what they see. They don't see the cases that we see, the cases that are successful. And I would say the statistics are probably about 90% of collaborative law cases reach a final resolution that is successful. And because it's created by the participants, it's about self-determination, privacy, confidentiality, there's more buy-in, there's more ownership of the outcome, and therefore there's less need for, say, parents having to go to co-parenting counseling post-dissolution of marriage because they're engaged in post-dissolution of marriage litigation, modifications of parenting plans and things like that. It's a more comprehensive resolution that's reached. And we see those positive cases. The litigation attorneys see the 10% maybe that drop out for whatever reason. And maybe it's because one participant doesn't want to fully disclose, or one participant wants to use the process to, manipulate the timeline, or just, we deal with so many different folks out there, so you just never know.
The other thing I would say too about that is that you don't hear people talk about failed mediation cases. I mean, that's not something that we're used to hearing.
Or failed litigation cases.
Right, and what is a successful litigation case, I would say. just interesting, the power of language around that, because that is something that I think has been and was with mediation a barrier to mediation really taking a hold 30 years ago or so,
Right,
right?
right.
And there was a huge backlash about redirecting cases away from litigation into mediation, and now it's just part of our way of being in our area. So
Part of our local rules, in fact.
right,
yeah.
exactly. And I did want to also say the transparency piece, one of the linchpins also of the participation agreement and the collaborative law process is the issue of transparency. There is no formal discovery. There is a commitment by the parties signed by the attorneys and the clients saying that we will fully disclose everything, and there is no behind-the-scenes strategizing.
And that's a contractual obligation under their participation agreement. It's also a statutory requirement under the UCLA, RCW 7.77. So and we read that agreement too. Our first team meeting, we actually read paragraph by paragraph around the table out loud that agreement. So everybody's on the same sheet of music. We all know what we're dealing with. The lawyers or the coach, if there's a coach on board yet, can chime in and explain provisions or answer any questions. So there's really that informed consent before a client signs that agreement. Okay, I think we've addressed this here. Creating shared solutions. That's really about, you think of people having positions, they're like these stated positions here, and there are reasons why they state those positions, and they're underneath, they're at the subterranean. You have to dig beneath and find out the why. Why is it that people have certain positions? Well, what you come to find out is that they have common goals. They have things in common that they value. So if you look at values and morals and so many other things besides, say, the law, you're going to get to that. You're going to get to the heart of the matter, and you're going to reach resolution. So it's creating shared solutions that are a win-win, that suit everybody's interests. That's the goal. Client directed.
Sorry. Just wanted to see
Yeah.
the roadmap. So once I think very visually, so I see this roadmap in my head. But once the participation agreement is signed and the parties commit to engaging in this process, typically there's a period of time where we go through information gathering. So because there is an agreement and a commitment to full transparency, if there are financial issues at play, typically there's a financial specialist that the lawyer team selects for the parties based on their understanding of their clients and their personalities, what would be a good fit for their particular case. When we recommend a financial specialist, then that's the person who does the information gathering. So it's a pretty cost-effective process because one person is the hub of all of that information. We don't have the situation where both attorneys are gathering all of the same information and then formally sending each other 150 interrogatories and requests for production to exchange that same information. You just have one hub of that information. And so that person can also really help promote transparency and full disclosure because that's a neutral person. And that helps the clients with their paradigm shift because they they see that they're providing this information to somebody with a financial background who is hired by both of them, not just one person's expert.
So it could be someone who's trained as a CPA, and maybe that's a better fit for the family because they have a family-owned business that needs evaluation, and this person does valuations, or a pension and can do the pension valuation. Or it could be a certified financial planner, or it could be someone who's trained in mortgages. And I have a case right now where that was the person that made the most sense because they're dealing with whether to refinance the house or maybe even buy another house for one of the spouses and the kids. So it depends on the issues you're dealing with. And so we've kind of walked through a lot of this already. So they find a collaboratively trained attorney. And what I'm finding more and more of, I don't know if you're finding this, is that people are educating themselves. They're reading online. They're hearing from other people about it. They're reading books that they find on Amazon about collaborative divorce or whatever the case may be. And they're looking for a collaborative attorney. And then others come in the door and you talk about their process options and they like the idea. Either they want to stay in court or they want privacy, or they don't want to spend an arm and a leg doing those interrogatories and requests for production of documents and, you know, the paper trail back and forth. They don't want to engage in the game. And then 3, we talked about addressing interests, concerns, goals. We actually address people's highest end goals. First meeting, what are your highest goals for the best possible outcome for you, for your spouse or the other participant, for your children? And it's not, I want the house, or I want the car, or I want my pension intact. Or I want 50% time with my kids, or it's higher than that. I want to have a good relationship with my kids. I want to be financially secure. I want to be able to communicate with the co-parent, or my brother who I'm, ending the partnership with, or my sister who, we just lost our mom, or whatever the case may be.
One I hear a lot is that that people want to maintain focus on their values. They want to be their best selves because they know, in a divorce case in particular, they have a high propensity to be their worst selves, and they want to try to maintain being their best selves through their process, given the circumstance. And that's something that I hear more and more. And even like with younger couples too coming through, they really want to maintain the core values that they have in their relationship and and just for themselves as a human being, and be fair to the other person. So those are those kind of high-end goals that we bring out in that very first meeting, and that sets the stage and the tone for the entire process. And then as we go through discussions, I'm sorry to interrupt, but this is the roadmap that I was talking. This is my favorite slide because it just sets out this is the process. But as we go through into steps 5 and step 6 and step 7, we keep coming back to step 3, which is that those the time that we sat together and created accountability to each other about those high-end goals. And when things get a little bumpy, we can refer back to those high-end goals. And so I'll say to my client, well, I remember when you were talking about, this, one of your goals was really to, be fair or to maintain that relationship. Do you feel like this particular situation is consistent with that? And so it does create that sense of accountability and reminding people what's really important to them.
I just want to say a word about number 4, addressing immediate concerns. So it could be something simple like, well, we're coexisting in the same house and it's pretty tense. Or what about not lapsing life, health, car, homeowners insurance, or not changing beneficiary designations and things like that. That's all already written into the participation agreement as part of the contract, is no unilateral changes, decisions, anything like that. We're going to work together collaboratively to make those decisions. So status quo, right? But the other thing is, under the UCLA RCW 7.77, and this could be a whole day-long or two-day presentation, we have a heightened duty to investigate and really inquire, not just initially, but on an ongoing basis, about domestic violence. And it's not to say that if there's any hint of domestic violence that the case cannot be collaborative. I think that domestic violence is often better handled in a collaborative law forum than court, for a variety of reasons, if you have the right set of professionals. So it's not to rule it out, but it's that you have to sometimes, if it's to the level needed, create a safety plan and have the right team and steps in place to be able to continue in a collaborative law case. So it's an ongoing heightened duty that I don't know that other lawyers really have, but we have that duty. So you address immediate concerns at the first meeting and as you go along, gather necessary information, and then you brainstorm solutions. And like she said, if you reach an impasse, you work through it and end up with mutually acceptable solution.
What that process looks like is that when you, it could look like that. But can you go back one?
Backward?
Yeah.
To your checklist.
Yeah, to my checklist. This is my favorite because I like. And I think
nuts
that's
and
probably
bolts,
the
really.
most helpful because people say, well, what does it look like? What's the process like?
Yeah.
The gathering information piece can be that financial information that I was telling you about, but it can also be gathering information about the children and having the child specialist meet with the parents. And the child specialist really has a very and again, all these professionals are collaboratively trained as well as trained in their own professions. So they have a child, a parenting plan worksheet that they work through with the clients and help them develop, again, an interest-based, focused parenting plan. And it's much more of an organic process that way. So we're not coming from, this is what the law says, and we're going to advise you accordingly. It's coming from a place of what really works best for the family, what's realistic, and what most recognizes the relationship and the possibilities for relationship after the divorce. So that's also part of that information gathering, and it's not uncommon for the lawyers to kind of be out of the picture for a while, as scary as that sounds, to let the parties work with their child specialist and let the parties work with their financial specialist in the gathering of information. And no decisions are made in those processes without coming back, because we are still advocates. We're still advocating for our clients, but we're also advocating for the process. And so,
and it is a legal process, so you can't eliminate the lawyers.
Right.
And we also check in with each other. So we have pre-team meetings or conferences or professional team email correspondence or conference calls, things like that. So we can hear a report back from the financial specialist. Or maybe it's the coach, like, she just lost her mom the other day. You guys need to be aware of that. Whatever's going on in their lives that might impact the process, it's a way to kind of touch base.
right. And the way that this is organized, it can be, you can look at this as there may be 7 possible four-way or five-way or six-way meetings, depending on which professionals are all at the table. And these are kind of the typical things that are addressed at each of those meetings. But like I said initially, as a team, we can condense that or expand it as may be needed by the parties and by the clients. But before each of these meetings, there's typically a meeting between each lawyer and their client. So our job in those meetings is not to lay out the law and strategize with the client. Mm-hmm. Our job in that meeting is to ask really important questions for the client to make sure that they're thinking about all those issues that they should be thinking about, and find out from them how they can bring that information best to the table. So we're helping them communicate what's important to them. And that's really, I see it as that's kind of the key role, to make sure that they're bringing the appropriate issues to the table, and to make sure that they have the support they need to do that.
And we call it leading from behind,
Mm-hmm.
right? So,
right, and then so we have those pre-meetings, but again, they're not strategy sessions. And then before the meeting, immediately before the meeting, on that same day, about a half an hour before the 4 or 5-way meeting, the professional team will meet and set the agenda. Although it's always flexible, the clients can change it as they may need to. But we set an agenda and talk about what's going on for our clients, so that when we then all get together, there's a good flow, it's efficient, and we're addressing all of the issues that need to be addressed. So that's a process piece that is helpful.
Yeah, I think it can really be about efficiency. So you
Mm-hmm.
have a good, productive meeting, and you're not spinning your wheels or anything like that.
Right. And then in brainstorming, so once all that information is gathered, and I know our time is short, but once all that information is gathered, then we have a meeting usually where the clients do just brainstorm they've had a chance to kind of think about things. The attorneys have kind of provoked them a little bit individually to think about possible resolutions. There's a lot of literature. It's pretty interesting on the value of brainstorming and what kind of brainstorming is more effective than others. When I first learned collaborative, when I was first trained, brainstorming was all about just throw anything up there, one idea
No
might
bad
be
ideas,
there are
right?
no bad ideas. You can burn the house, right? Instead of, whatever. I mean, but there's some shifting in that concept, that maybe that's not really as effective in finding creative solutions, that maybe it's more effective to have people think about more realistic solutions.
But sometimes you'll hear things from clients, and instead of the lawyer placing any kind of judgment on it, well, that's not consistent with the law, or what have you, put it on the wall. We're not there to judge. Right. If it meets their high-end goals, at the end of the day, that resolves their dispute, right?
Right, yeah.
Can I move forward?
Yeah, and then just that last piece is that once that brainstorming is done, we have all these ideas literally up on the wall, then they start going through. They each prioritize which idea seems to work best from them and what the underlying interests are for each of those scenarios. The financial would have weighed in on running different scenarios. Well, this is the spousal maintenance package plus wife keeps the home. This is the spousal maintenance package if wife sells the home. So all those kinds of scenarios, the clients themselves would have narrowed it down to a few of those scenarios for the financial person to run. And then they would have that information on which to base which scenario seems to fit best for both of them. If that makes sense.
And that I find to be really empowering for people, to see it all laid out into 3 different scenarios, say, and they can evaluate them. I think information is power, so they've gathered the information. It all comes together in a form that everybody can understand, and they can have an informed decision at the end about what works best for everybody. So it can get sticky. You know, where I was talking about having breaks or food on the table. I mean, food sustains people. It's like breaking the bread. Or saying, well, maybe we need to do a little more homework on this issue and reconvene about it once we've gathered more information, or what have you.
The thing I like about this slide is I think it's a poignant illustration of the difference between cooperative law and collaborative law with a capital C, in that, and I'm just saying this totally off the cuff, but in collaborative law with a capital C, you don't get your weapons. You have to say,
Right.
I'm coming to the table and I have an intention to settle this, and I'm not going to threaten you into settlement by saying I'm going to bring out the big guns and take you to court if you don't settle. And so I think that's a good illustration of that it doesn't just start out politely. You move through each stage, and you're constantly, the parties are constantly reminded of their own commitment and their own values.
And I want to just say another word about cooperative practice, because I think that it's risky, really, for lawyers to engage in that kind of process. First of all, I think that as lawyers, we ought to cooperate anyhow. I mean, whether you're in litigation or mediation or arbitration or collaborative law, we ought to be mature enough to have some level of professional decorum and respect for one another as colleagues and professionals. So I think that should go without saying. But cooperative practice really is about, well, okay, we need these financials. Can you get them to me and I'll get yours? You know, informal discovery, that kind of thing. Well, you can cooperate all day long till the cows come home, and then you're a week before the trial date. You don't have the protections that collaborative law gives you by having the contract and RCW 7.77 behind you that mandates full disclosure, that mandates good faith. So I think it's risky, because I think a client could turn on you and complain that you didn't do the formal discovery that maybe you should have done in a litigation case. So I tend to be of the mind that it's either collaborative or it's litigation, because at the end of the day, you've got the case schedule from the court, you've got discovery cutoff dates. If you don't comply with those, it's a problem. So if you're relying on your opposing counsel to get you the information you've requested and you don't get it, it's a problem. Whereas in collaborative law, I trust my colleague will comply with that contract and that statute, and will get her client to comply too. So it's just my take on it.
This is
This is
more.
the how.
Yeah, this is more of the how. This is more of a closer, more detailed view of what each meeting looks like. And food, there's always food. I always thought that was curious when I started. It's like, why is there always, you don't get a bunch of food on the table when you go to an all-day settlement conference. Maybe
Unless it's
you
in
get,
my office.
right,
I
or
tend to
mine.
provide food
Yeah.
if I'm hosting the mediation, because
Right.
I've learned that if people have breakfast, they have lunch, they have a bathroom break, you know, they take care of their human needs, they're better able to resolve conflict. So I've carried a lot of what I do in collaborative law to the litigation, you know, mediation realm, and I
Yeah.
think it works.
Yeah,
for
as
some
I
reason.
have. Yeah, I think the training, even if you're not sure about being a collaborative practitioner, the training is invaluable, because it really does get you thinking about conflict resolution a different way, and from a place, a more humanitarian place. You learn a lot about things like that, like what's going to put your client in the best situation to make a good decision. We learn a lot about how your brain shuts down under times of anxiety, and what you can do in the process to slow things down so that people aren't making the most important decisions of their lives under the highest level of anxiety they can ever have. But
we were talking earlier about giving credit where credit is due. We gave credit to Stu Webb, and you mentioned the brain. Pauline Tesler is the founder of the International Academy of Collaborative Professionals. She was engaged in high-end, high-conflict family law litigation in the Bay Area, like Palo Alto, San Francisco Bay Area, and really took collaborative law, I think, to the next level internationally. And lately, and she's written all kinds of books. So if you go to Amazon, you'll find books by Pauline Tesler. She has one that really goes into the how-to. It's got an appendix to it that I include in my packets that I described earlier. It's a blue book, Collaborative Practice, I think it's. Well, the website for IACP is collaborativepractice.com. So you'll probably find a lot of resources there. But this book goes into the how-to, and she's got a CD at the back of the book that has all kinds of forms and letters and participation agreement and whatnot. But our organizations, King County Collaborative Law and Collaborative Law Professionals of Pierce County, have our own forms that we've adopted as well that, you know, follow these models. But now Pauline Tesler has elevated her practice even further to integrative law and brain science, and she talks a lot about the brain and conflict and trauma and what trauma does to the brain and decision making and so forth. So we do integrate a lot of that into collaborative practice. What else?
that's one of the things. I think she was really inspiring to me because she helps kind of take this just real world look at us as human beings, as mammals on the planet. We're social beings and we thrive in community, and it's really interesting to learn how our legal system and our conflict resolution process has evolved or devolved away from what is most natural to us as human beings. And so there's just a lot of really interesting there are a lot of interesting trainings and a lot of interesting literature about that in terms of just kind of getting to your core as someone who wants to be of service to people, which most of us lawyers really do want. That's something that really unifies us, but how we get there can be just so very different. So anyway, I would encourage you to read Pauline Tesler's stuff.
This here, we've talked a lot about this, having an agenda, setting the place, and we alternate between offices, so there's, no one attorney is hosting every time, and unless people want it otherwise for geographic reasons or what have you. Modeling behavior, so, the way we talk to each other and the way we talk to our client and the other client, and building rapport too. Me building rapport with Alexis' client is going to help and go miles to resolving the conflict. But between meetings, we assign homework at the meeting. We set an agenda for the next meeting. And so those clients who want to move more quickly, you have to encourage them that there's work being done between meetings. It might be go get a comparative market analysis on the home, and you go get one too, and let's compare and try to arrive at a value. And we take minutes, and we alternate that duty. So I'll take minutes of one meeting, and then Alexis will take minutes of another meeting. And that's to memorialize what the agreements were that were reached at each meeting. So the idea is you have little mini agreements reached along the way that end up into a global marital separation agreement, or, if it's another kind of dispute, an agreement, a written agreement. Okay.
So there are a couple of things too in that process that are interesting. There is a really high expectation of parity. So lawyers are, we alternate where these meetings take place unless the parties conscientious, just intentionally want it to be somewhere else, or at one attorney's office all the time. We alternate the meeting minutes. We also typically agree on, and this may be done outside of the meeting, but after the meeting, there's usually a kind of a debrief session, kind of getting us set for what we need to do between that meeting and the next meeting, kind of debriefing how it went, just to make sure that we're all on the same page, and if any intervention needs to be made. But in that debrief, we'll say, how much are you billing for today? And the attorneys bill the same amount because it's presumed that the clients will compare bills. And so there's a lot of transparency that we as lawyers are really uncomfortable with. And the other piece is that I will talk, if Leslie's the attorney, who's my teammate, I will talk to her client directly. And typically, it works best when I'm telling her client or eliciting information that's positive about her case, or I'm talking to her client about maybe a way that the law doesn't support my client's situation or what my client wants in the case. So I'm the one who'll deliver the good news to the other client. Leslie will deliver bad news to her client. So that's kind of a little bit of the intensity of the training, but also the balancing and establishing that rapport and trust that are really key components of the process, really developing trust among all four. And I know from one of my trainings at IACP, I think it was somewhere in Santa Barbara, there was the collaborative law group there did a presentation for the judges, and they described this process. One of the judges said, "What? You let your client talk?" So there's a lot of real resistance about having your clients be super involved in the process, but that's what really
self-determination.
is most empowering. Yeah.
Also, I think lawyers and other professionals on the professional team need to be open to criticism. And so we learn a lot about ourselves. I know I'm part of a book discussion group, and I've read countless books with this group about mediation and collaborative law and Buddhism and mindfulness and, bringing peace to the room. What baggage do I bring to the room? What buttons are being pressed by Alexis' client or my own client that I need to check at the door or deal with or process or something like that? So in the debriefing, I need to be open with Alexis telling me, when you said it in that tone or that way, it didn't really work as effectively as had you said it in this way, or that kind of thing. So we really have to be mindful, I think, when we come to this process. Also, just a word about transparency and fees too. I mean, you were saying the same amount. I don't think it's necessarily the same billable hour or the same. My client might be calling me less often than Alexis' client is calling her. Might need more. Involvement, attorney-client communications than my client needs. So there's at least that discussion, that transparent discussion about, that may be a difference that they see, or it might be that, the professionals need to be paid. So, like as lawyers, we're going to want to make sure that the financial specialist gets paid, and how's that going to happen? Well, he earns 62% of the income and she earns, the rest, and so maybe we need to disproportionately have that financial specialist paid in those percentages. And we've talked about privacy and managing the pace and really having the clients dictate that, but not allowing one to control whether it moves slower or one to control whether it moves more quickly, but really to synchronize the two. And we talked about this a bit. Never giving up. So I have no idea how much time we have. Okay. If we have time for questions or not. Yeah? Yes. Oh, we can share. We can share.
Oh, yeah, I better use that one. This one's under the chair.
Is there any effective way of enforcing good faith or pursuing lack of good faith given the statutory privilege?
The attorney-client privilege, is that what you're referring
Well, the
to? in terms of-
collaborative law
Or the
communication
statutory
privilege.
privilege for collaborative law.
Yeah, so
Mhm.
with that there and everything that goes on in collaborative law, so you have all that, and later it becomes apparent after all is
Yeah.
done that somebody didn't fully disclose a material item and so forth. Yet comparing it to the mediation model, there the mediator makes sure the mediator cannot be called in, and
Right.
so you have that tension between the duty, but with the privilege, what enforceability?
There is a bit of that tension, and I'll give you an example, and it's a case that I had where child support and spousal support were at issue, and my client was residing with another adult, and she did not want to disclose the other income of that adult, and I said, you must, and you will, or I will have to terminate. And if I had had to terminate, I wouldn't be able to tell the team why. It's that the case is terminating as a collaborative law case. And I give notice, and there's 30 days, so there's no surprise. And I can't tell them why because of attorney-client privilege, but I can't go on because of the duty of full disclosure and good faith. And I'll tell you what, she produced those documents. And I'll tell you what, my collaborative colleagues trust me because they know I will hold my clients accountable. And I trust them. And therefore, when I have a client who says to me, I know I'll engage in full disclosure and good faith, but I don't trust him or I don't trust her, I say to them, trust the process, trust the statute, trust the contract, and trust that his or her own lawyer will make sure of that. Otherwise, the process must terminate.
So when you have a responsible attorney involved, that solves one part of it, but not all of it, it seems to me. Try to think of a hypothetical. Pre-divorce coaching attorney says, Guy, you need to buy another year or at least 6 months. I suggest you go to this collaborative lawyer, get involved in the process. Collaborative lawyer never learns that there's something coming up that would have affected the settlement, and it gets settled. So we're still left with the issue of how do you prove lack of good faith that something wasn't disclosed if that which is going on maybe verbally in the collaborative law sessions is privileged.
So are you saying the collaborative law attorney becomes aware or does not
No,
become
doesn't know.
aware?
Doesn't
know.
No, I'm coaching Daddy Warbucks out here.
Yeah, yeah.
I'm saying, look, you need to buy some more time. She needs to finish this school, be able to start self-supporting or whatever.
Right.
Get in there, do this thing. Maybe you decide not to settle. Maybe you decide to settle if she does what you want. Or maybe you want to get it settled now before this great news breaks for you. Surprise, surprise. So I'm looking at your slide on the privilege, and I'm saying, so how do you prove? How do you prove that there was not that there was a lack of good faith, or maybe it's more subtle. Maybe it's a stalling mechanism for some other purpose, and the collaborative attorney does not know about it. So you've got privilege. What went on in that session, and can it be brought out that this was never disclosed? How do you get beyond the privilege?
Well, I'm not going to lie to anyone and say that there aren't people out there who don't abuse the process, right? And come into it with bad intentions and want to use the process to control their spouse and are getting advice from an outside, litigation attorney or whatnot. I mean, I think we are trained to recognize that. I think the marital separation agreement that we all use, we have a template that's approved by our protocols committees for these organizations, has language in there that covers, undisclosed assets and, that they've. So, I think that it could be, let's say the case concludes, reaches a resolution, and later there's discovered some undisclosed asset. I think that it could be brought to court. The marital separation agreement could be brought to court, and
That's getting right at what I'm talking about. So
Yeah.
it can be brought to court. So somebody goes in and says, this is a dirty deal. That was never disclosed. And the other says, number one, you can't talk about what happened in the mediation. Number two, it was disclosed.
the confidentiality provisions of the participation agreement are very detailed. They're probably, I'm going to say, a page and a half, if not at least a full page, of exceptions and, anything that would ordinarily be discoverable, like financial statements or financial declarations or sworn statements. Those aren't kept confidential, but the minutes of the meetings are confidential. The coach can't come and testify. The financial specialist can't come and testify. And certainly the attorneys wouldn't ever come and testify. So, there's those protections. Yeah. But, I guess the other point is, how many folks out there are hiding the ball in litigation and, not fully answering interrogatories or providing documents or, hiding some bank account that never gets subpoenaed or it's a tough one. I think there are greater protections in collaborative law with the contract and the statute than we have in the litigation setting even.
And I would say also that, I have seen cases in mediation that people abuse the mediation process. You get to the very cusp of an agreement, and then they say, just changed my mind. And it's about buying time or whatever. And it's the same challenge because there are some mediators who just will not provide any information, even though under the statute they can provide information that pertains to whether somebody was fully participating or not, attending meetings or not. But it's pretty limited, right? And that's the same kind of limitation we have in the collaborative process. But as Leslie said, there are a few more hoops to go through, and it's a really expensive way to delay, potentially, because you will have a neutral who's the person who's gathering the information, but also when a party says, I'm not really trusting that person, that neutral's looking at the tax return to make sure they're getting everything. There's another layer of accountability that isn't necessarily there when you're just straight out litigating and doing a formal discovery request. So the other interesting thing I think it's important to point out is that under the UCLA, the Uniform Collaborative Law Act, training, the full collaborative law training is not required. So a lot of attorneys are out there saying they practice collaborative law, but they're not collaboratively trained. And without the training is very different. It is a paradigm shift. You're learning really different ways of looking at things. And so if you engage in a case where the other side says, yes, I'm a collaborative lawyer, then look them up on KCCL. Just because they're not there doesn't mean they're not collaboratively trained. But if they are there, it should mean that they're collaboratively trained. And that's King County Collaborative Law. They are typically going to then also be members of the International Academy of Collaborative Practitioners. So you can go look on that website as well.
Right, and there's a website for Pierce County as well. So, I've had examples of I've had examples of clients who've gone to a lawyer wanting collaborative law, and the moment the lawyer hears the word conflict, even though they have a full-page ad about collaborative law, so they got that client in the door, they say, well, you must go to court. The key is every case has conflict unless it's uncontested. It's the manner in which you resolve it, the forum in which you resolve it. So she ended up in my office because he was going to take her to court, and she didn't want to go to court. So, people should really investigate that although the UCLA doesn't require training, look to independent sources like these websites of, reputable collaborative law organizations that have protocols in place and standards in place. Any other question? Yeah?
Yeah. So, if I understand correctly, the excuse me, the participation agreement that the parties and that the clients and the lawyers sign is it. How exactly does it prevent threatening litigation? As I understand it, it's because the lawyers must withdraw from the representation. Is there anything else in there that acts as stopping the parties from threatening litigation?
Yeah. I mean, I would say that just as much as the confidentiality provisions take up a good page, the good faith provisions also take up a good page, and they're well defined, and they're reviewed, and they're discussed. And so it's pointed out that we will not threaten court. We will not schedule a hearing. We will not file pleadings with the court unless we do it jointly and we decide when together. And we will not schedule a hearing or threaten to go to trial or any of that. That's just not going to happen. So it's laid out from the get-go. It's not that we don't talk about what happens in court. We talk about it as we don't lead with the law. The law certainly is a component. It is a legal process, and we do talk about the law, but I think we choreograph how we talk about it. So we talk about maybe there's a football field of options, or there are 22 judges on the bench in Pierce County, and here's what they might say about spousal support. But you didn't choose that process. You didn't choose to litigate that issue. You chose this process. So what's going to work for you, and what's going to work for you as a final outcome? It doesn't matter what those judges say, really. Does it work within your budget or your yeah?
Yeah, so I would say the other piece of, and I think you were asking also, what else happens if you threaten litigation? You risk losing your attorneys, but you also lose those neutrals that you've worked really hard with and usually spend a bit of money working with. And especially when kids are involved, my experience is that people develop pretty good relationships with their coach and their child specialist, and they're very instrumental in getting people to come to the table in good faith. And the thought of losing those professionals and starting really, truly from scratch is a linchpin of the process. It does really keep people involved, and it is also one of the most, if not the most, controversial piece of collaborative law. And it works. Yeah. It works. Yeah.
Well, thank you very much.